On Government Order of the Day number 3.
Health Protection Amendment Bill, third reading.
The Honourable Dr Jonathan Coleman.
Mr Speaker, I move that the Health Protection Amendment Bill be now read a third time, and I'd like to acknowledge the officials and the members of the Select Committee for their work on the bill. There were 71 submissions and the committee heard 22 oral submissions, and I know it was a most constructive process, and I'd like to thank other parties in Parliament for their support of the legislation. This bill amends the Health Act 1956, and back in October 2013, the government decided to improve the range of measures in the Health Act in two specific areas. Measures to protect the public from the risk of sexually transmitted diseases and the spread of some infections, and then unrelated but obviously within the same bill, in the case of people under the age of 18, measures to protect them from the harms associated with UV tanning. This bill is going to protect people from those preventable harms, and it will do so through a range of measures that are proportional to the risks that are faced. Mr Speaker, New Zealand has high rates of sexually transmitted diseases, and of course such diseases affect individuals, families and communities. There are a variety of potential complications which stay with people for life, including chronic pain, infertility, neonatal morbidity and genital tract cancer. So these diseases are serious matters indeed. The bill adds new provisions for the surveillance and management of infectious diseases, and those measures will improve the availability of information on certain conditions. They'll provide for more effective management of behaviours that put others at risk of infection, and they will strengthen the legislative provisions for contact tracing. The bill establishes a clear legal basis for the principles applying to medical officers of health and the courts in the exercising of their disease management powers. People exercising these powers will be required to take into account any known special circumstances or vulnerabilities of the individual concerned. These may be due to youth, may be due to disability, incapacity, or a range of other circumstances at the discretion of the officer. The bill requires that measures are proportionate to the public health risk that's being managed. So we don't have a situation where a sledgehammer is being used to deal to an acorn. People get to manage or exercise discretion in the range of measures applied. The principles also encourage individuals to take responsibility for their own health and the health of their communities. Currently, sexually transmitted infections, with the exception of AIDS, are not notifiable by medical practitioners in New Zealand. The bill makes HIV infection, gonorrhea and syphilis notifiable on a non-identified basis, along with AIDS. The notifying information for STIs needs to be sufficient to enable different kinds of public health interventions while making sure that there is that they are complying with privacy safeguards. The bill requires notification of serious STIs while protecting the individual's identity from being disclosed in the first instance. Reluctance to disclose information or to be diagnosed and treated could arise from fear of consequence as a result. However, this information can be vital to help identify others who may be at risk and to prevent further spread of infection and disease. The bill says that information requested and provided under Part 3A will not be used or disclosed for any purpose other than for the management of infectious disease. Contact tracing is a very valuable public health tool in preventing and managing infectious disease outbreaks such as gonorrhea, measles and meningococcal disease, and is a very important tool for public health officials. Subpart 5 of the bill extends contact tracing powers to contacts of people suspected of having an infectious disease, allowing speedy follow-up and diagnosis, and then of course treatment and containment where appropriate. On looking at this bill's impact on existing venereal disease legislation, the committee decided that it should be replaced by this bill. The current definition of venereal disease is not fit for modern conditions. For example, it doesn't include HIV infection, it doesn't include AIDS or chlamydia. Other outdated legislation that the bill will repeal includes Section 79 of the Health Act. This authorises a medical officer of health to detain and isolate people likely to cause the spread of an infectious disease. Part 3A effectively replaces Section 79 with graduated powers of increasing robustness when an individual refuses to comply with management aimed at preventing other people becoming infected. On to Part 2 of the bill, which prohibits the commercial provision of artificial ultraviolet light tanning services to people under the age of 18. A complete ban on the provision of artificial UV tanning services would prevent access to artificial tanning services by adults who are well informed and choose to take on that risk. The Health Committee reported back that it's satisfied that the bill will protect the vulnerable under 18 age group while allowing adults to make informed decisions. That's comparable to other legislation such as the sale and supply of alcohol, which recognises that 18 is an age at which people are capable of making their own choices. Clauses 8 and 13 of the bill include several new provisions. These provide an infringement process to deal with breaches on the ban of providing artificial UV tanning services to people under the age of 18. This process would deal efficiently with offences and prevent expensive and time-consuming criminal prosecutions. Voluntary standards and guidance on operating sunbeds exist. However, surveys have found that there is variable compliance with those steps designed to minimise harm, despite the considerable effort that's gone into educating operators and to encourage compliance. I've therefore asked health officials to look into whether licensing of premises and operators and the introduction of mandatory standards is indeed appropriate. Because of the danger that sunbeds potentially pose, it's important to have a licensing and training regime that ensures that cowboy operators can no longer exist in this particular industry. I've asked officials to provide advice on a range of possible measures, including licensing all sunbed premises and operators, requiring that operators are trained to ensure that the risks of sunbed use are minimised, and insisting on clear information being provided to clients before they jump on a sunbed. Mr. Speaker, this bill improves the protections we have for the health of New Zealanders. It's an important part of the legislative framework for managing and reducing health risks, and I commend this bill to the House.
The question is that the motion be agreed to.
Mr. Waiter. Mr. Speaker.